Good evening, and welcome to the July 2016 Richardson Law Office's Legal Hangout. I'm Steve Richardson, and hopefully we'll have better luck with our technology this month than we did last month. As you may have seen on the channel, the show I did on handling medical debt, dealing with medical debt, went well, just that there was no audio. So you could see me talking, but you didn't know what I was talking about. So we've been working on the technology. I'm actually broadcasting this using a different computer, and hopefully that'll do the trick. So that's this month's Hangout. We're talking about how to deal with medical debt, which can be a very different situation than dealing with credit card debt or other types of debt. So it really deserves its own program in that regard. So if you're dealing with medical debt, and you need some strategies, well, we're going to talk about that today. The first thing you want to do in approaching a problem of medical debt, and sometimes it can happen from just an unexpected illness or injury. You spend a lot of time in the hospital, the bills can really mount up. So the first you want to do is get all your information together. You're going to want to get the treatment records from all of the hospitals and medical professionals. If you do have insurance, you want to get all of the EOMBs, the explanations of medical benefits. That breaks down for each bill and each service, the servicer, and whether they're in or out of network, which I'll get into in a minute, and what's being paid. So you want to get all that together. And the billing statements, of course, you have the EOMBs. So you get the treatment records, the bills for that treatment, and the information from the insurance company, if you have insurance, on that bill and what they paid and what you're responsible for, etc. And also, because your income and ability to pay can be a factor, get your tax returns together, some income records to be able to substantiate that. So you get that together. What's the first step? Well, let's deal with, first of all, if you have insurance. Because even if you have insurance, it can be a struggle. So we want to make sure we approach that first. So compare the bills that you get with the explanation of medical benefits. Because the numbers may not always line up, and you want to make sure they're accurate. Because the comparison of the bill to the EOMB can raise some issues. If you're on Medicare, then Medicare pays, depending upon what your Medicare coverage is, will pay 80% of what's reasonable and customary, and you're responsible for the other 20%, unless you have supplemental insurance, or what is often called Medigap insurance, which can pay the other 20%. If you have that, and then what is paid by Medicare is considered payment in full. So if there's any kind of balance billing, that can be a red flag. And the same thing is for Medicaid. If you're on Medicaid, and that's a case where it's not even 80-20, where Medicare will pay 80% of reasonable customer, and you're responsible for the other 20% unless you have supplemental coverage. With Medicaid, whatever they pay is payment in full. So you want to make sure that the provider is not balance billing, is not trying to get, well, we bill this amount of money, but Medicaid only paid this amount. Well, you're on Medicaid. Whatever Medicaid pays, that's it. There is no balance billing. And same thing for Medicare. So you need to look at that and compare those. Also, there may be balance billing if you just have regular insurance, for example. And this can vary whether your carrier is a preferred provider network or if they are a health maintenance organization, an HMO. But if they are in network and they've agreed to accept that, well, they can't bill over and above what the insurance company says this is what gets paid. So let's say they bill $5,000 for a procedure, but the insurance company says, no, you're in network, it's only $3,500. We'll pay this portion of the $3,500, and then depending upon what your policy says regarding co-pays and deductibles, you may be responsible for a portion of that $3,500. The provider cannot balance bill, cannot just bill you the other $1,500. No. They agreed to accept $3,500, not bill $5,000. So you want to make sure that's correct, and then you're not being billed for something you're not responsible for paying. And also, New Jersey laws and regulations provide that a medical provider's failure to submit a timely claim for insurance coverage may give rise to a defense similar to the Medicaid full payment defense, thus precluding that provider in many or all cases, seeking payment in whole or in part directly from the patient. So that provider has to make timely submission of that bill to your insurance carrier. You know, they screw up. They don't send it in when they're supposed to, and according to their agreement to take that insurance, and as a result of late billing, it gets denied. Well, that's not your fault. So that could lead to a defense as well. So, be aware of that as far as when it was billed. Now, there can be issues with in or out of network. This has become less and less an issue, but first of all, emergency services are always considered in network. So if you're taking the emergency room, you don't have to be lying there on a stretcher worried about whether they're taking you to an in-network hospital or not. Emergency room services are always covered. Now, that with the emergence of a lot of urgent care facilities that you see popping up, if you go one of those, there may be an issue as to whether that is emergency services or not. But if you have to go to the emergency room, that's always covered. It's always considered in network. Now, there may be a portion of it that you're responsible for due to copays and deductibles under your policy. But as far as in network versus out of network, it's always considered in network. Now, most out-of-network charges at in-network hospitals are prohibited under New Jersey's administrative code. And just that brings up an issue too for those who are watching my legal hangouts and everything. Just as an aside, this is all having to do with New Jersey law or applicable federal law. So if you're watching from another state, just be aware we're talking about New Jersey's laws. And I'm really not offering any kind of advice or suggestions or tips for anybody living outside of New Jersey. So again, our administrative code says most out-of-network charges at in-network hospitals are prohibited. So sometimes what will happen is, and it's called service unbundling. The hospital may be in network, but they subcontract out a lot of services. Sometimes the people that run the emergency room are different. The anesthesiologist, the radiologist, all these different services, they might subcontract out to another entity, and that entity will bill you. But there's a question as to whether they're in network. So that can become an issue. But most charges had to be considered in network. All contracts issued by health maintenance organizations and health service corporations and all selective contracting arrangement policies issued by insurance companies shall provide that a covered person's liability for services rendered during a hospitalization in an in-network hospital, including but not limited to anesthesia and radiology, I mentioned those two, where the admitting physician is a network provider and the covered person and or provider has complied with all required pre-authorization and notice requirements, shall be limited to the co-payment deductible and or co-insurance applicable to the network services. So again, the hospital or medical provider cannot bill above what they agreed to accept from the insurance company. Now this is also true that a covered person's liability for services rendered during a hospitalization in a network hospital, including but not limited to, again, anesthesia and radiology, where the admitting physician is an out-of-network provider, shall be limited again to the copay, deductible, and/or coinsurance applicable to the network services. Now, be aware that it can depend on where you get your benefits. Self-funded employers and union plans aren't covered by these rules, but they may also offer similar protections. So you need to take a look at that paperwork as opposed to these administrative codes. But even with these rules, some problems can crop up. There are still, you can have an insurer and an out-of-network provider can't agree on a payment amount. They start getting into a fight over it. We're not ordinarily in your network, and we usually bill for more than this, and that can be an issue. A reimbursement check, which might or might not be enough to pay the out-of-network provider in full, sometimes goes to you instead of the provider. But this usually doesn't happen since 2011 in managed care plans if there's an executed assignment of benefits where the insurer is authorized to pay the provider directly. But you can still have problems arise as a result of this. There can be a controversy of the legality of a deductible, co-payment, or co-insurance waivers by out-of-network providers who do receive payments for insurance, whether it is that they're trying to get more money. I talked about unbundling of services earlier, where you have the subcontractors to bill separately that may not be in network. This is contracted with staff physicians and other medical practices to provide services such as emergency room, et cetera, as I mentioned. So you may find yourselves billed for outside provider charges despite eligibility for charity care, in-network insurance benefits, Medicaid, Medicare, or another healthcare benefit program. So you need to, again, take a look carefully in comparing the bills that you receive with the explanation of medical benefits to see how it's being handled, how it's being paid. Now, again, if you don't have insurance, there might be other ways to get the bill paid, and I'm going to provide in the show notes for today's Hangout some links to some websites to give you further information. Of course, there's Medicaid or Medicare. There's charity care if you're uninsured or underinsured, and I'll leave a little link to that so you can take a look at that. There's New Jersey Family Care. There's the Pharmaceutical Assistance to the Aged and Disabled, PAD. There's the Catastrophic Illness in Children Relief Fund, and the Victims of Crimes Compensation Board. This is a fund that's set up by the state of New Jersey to just that. If you're the victim of a violent crime, you've been assaulted, and you're severely injured, you require medical treatment, there is a fund maintained in New Jersey to help people defray the costs of medical treatment as a result of a violent crime. You may have even heard this if you've ever been in traffic court. A lot of times, part of the penalties and fines and everything else can be they may assess a $50 violent crimes compensation payment. So that it's funded by people that are pleading guilty or being found guilty of certain charges, and they have to pay into this fund. But it can help you out if you've been the victim of a violent crime. But check out those links below. But things like charity care can be very helpful. It provides broad and comprehensive coverage. Persons determined to be eligible for charity care cannot receive a bill for services or be subject to collection procedures. So again, just like Medicaid, if you're on charity care, and whatever charity care pays is whatever the provider has to accept it. They can't balance bill you. And Medicaid and Medicare can cover a lot of things. There's, again, strict limitation on balance billing. Now, participating providers are prohibited from billing Medicaid or New Jersey Family Care beneficiaries for any amount except 1, for services, goods, or supplies not covered or authorized by New Jersey Medical Assistance and Health Services Act, or not covered by the authorized by the Division of Medical Assistance and Health Services, if the beneficiary elected to receive the services, goods, or supplies with the knowledge that they were not covered or authorized. So this is a matter of communication between you and the provider, a medical provider, as to what is covered. If they didn't give you proper notification of things that weren't covered and you thought it was, then that can help it. If you get the services and you knew they weren't covered, you can end up paying for it yourself. For payments made to the beneficiary by a third party on claims submitted to the third party by the provider. For New Jersey Family Care Plan C enrollee contribution to care responsibility, or for New Jersey Family Care Plan D enrollees required copayment. Now, I mentioned the pharmaceutical assistance to the aged and disabled, PAD. There are certain eligibility requirements, so you should check into those to see whether you can qualify for that and help and get that to help get your bills paid. You have to be a New Jersey resident. You have to be 65 years of age or older, or 18 years of age or older and receiving Social Security Title II disability benefits. So either retired or disabled under those rubrics. Your annual income for the year, and this is 2016. So your annual income has to be less than $26,575 if single, or less than $32,582 if married. And finally, Medicare eligible PAD beneficiaries are also required to enroll in Medicare Part D prescription drug plan in New Jersey. So, and this is all provided on the website where I'm giving you the link, so you can look it up there as well. But what happens if you don't have health insurance? You can't get Medicare or Medicaid. You can't get the bill paid by these other providers, and it's all on you. What do you do? Well, the key is to be proactive. What's interesting about medical services is that it's really the only area where you agree to receive the goods or services and agree to pay for it, but you don't actually agree to an amount. You know, basic contract law says if somebody offers you to sell you goods or to perform services and you accept that offer, and there's a clear understanding as to what the payment is to be for it, for those goods or services, then that's a contract. It doesn't always have to be in writing, but it has to have those three things: offer and acceptance, and what's called consideration. In other words, both sides get something out of it. You get the goods or services, they get money, okay, or some other form of compensation. But with medical services, they make an offer to provide goods and services for treatment. You agree to have the treatment done and pay for it, but you don't agree to an amount. So really, once the services are provided, you enter into negotiations on how much you're going to pay for it. And that's really what it is. So when you get the bill, you know, they deserve to be paid. Maybe not the amount that they're billed, but treat them fairly, contact them in a timely manner, and start negotiations. Because there may be some other defenses that come up as a result. There may be a dispute over the amount or the basis of the bill. Or where do they come up with the number? You know, is that what medical providers in the area charge? Or are they way overcharging you? Disputes over a legally responsible person. If, you know, in New Jersey, if your spouse receives the treatment, then under a duty to support, you, the spouse, are responsible as well. You may not receive the treatment as your spouse, but you could be held responsible. But what if it's a parent or a child and they're billing that person? You can argue, wait a minute, I'm not responsible for their medical bills. So there may be an issue of the legality of whether you're legally responsible to pay the bill. That might come up. And of course, disputes over third-party responsibility. There may be an insurance issue because the insurance carrier has denied coverage, so that you may end up in litigation where the provider's coming after you for payment, and then you have to bring in the insurance company to try and work out whether the insurance company is responsible to pay, whether they shouldn't have denied the claim, or whether they should pay it. Then there's disputes over whether the provider met their obligations, especially as to information assistance with obtaining payment assistance, where they should tell you about charity care, about PAD, about some of the other options that you have. Maybe they didn't tell you about that, and as a result, you couldn't make timely application. But again, as to disputes over the amount of the bill, could exceed reasonable value of services. It may be way above what other providers in the area are billing. You may not have been properly credited for payments, so you check that. Some items are excessively or outrageously priced. And of course, or you might have declined treatment if you knew they were going to charge you as much as they had. So reasonableness of the bill really comes into play when it comes to, let's call it haggling. Okay, that's what it is. You're haggling over the bill. You're haggling over how much you're going to pay for the medical services. You can, but you may also have some other legal defenses in addition to the amount of the bill. New Jersey law provides that a licensed hospital may not charge an uninsured New Jersey resident patient whose family gross income is less than 500% of the federal poverty level. So if your income, and you need to check the federal poverty level and whether your income is less than 5 times that. If you fall below that, they can't charge you more than 115% of the Medicare reimbursement rate for any service. So if you are low income, check that tax return I told you to get together, and and then find out what are the Medicare billing rates, because you can't charge me more than 115% of that, and that gives you a baseline. That gives you information that empowers you in the haggling process with a medical provider, because you can say, here's my tax return. Here I am below this threshold, therefore you cannot charge me more than 115% of what Medicare would pay. So I need to know what Medicare would pay. So you need to get that together. So that empowers you. And under new IRS rules, a 501c3 charity and tax-exempt hospitals can only charge patients eligible for any type of financial assistance the amounts generally billed to insured patients. So it's show me an insurance company that would pay this bill. Okay. So, you say, hey, look, you're a nonprofit, you're a charitable organization, you're tax exempt. You can't go charging people that much. Okay. So that can come into play. So check out the hospital. Check, are they a nonprofit? Are they a 501c3 charity? You can find that out from the IRS website. Now, there are other legal defenses. They may not have complied with the charity care regulations. You might have been able to be eligible for charity care. That didn't work out. They didn't follow the regulations. There may be a defense there. They may have violated New Jersey's unfair claims practices laws on regarding prompt payment of claims. Now, you also have what's called the New Jersey Hospital Patient Bill of Rights. All right, and that basically goes to patients have a right to examine and receive an explanation of their bill, regardless of the source of payment, and to receive information or be advised on the availability of sources of financial assistance to help pay for the care as necessary. So this is a right for information to receive this. I have an explanation of the bill. Why are you charging this? What's it based on? How did you come up with the number? What resources are out there? What programs are out there that help me pay the bill? And of course, the Affordable Care Act has regulations limiting charges for any patient eligible for their financial assistance policy assistance to the amount generally billed. So the idea is to negotiate the bill, and these laws can empower you and give you the information you need. Now, there's also something called the Healthcare Blue Book, and I'm also going to provide information and links in the show notes to that, where you can get an idea and look up those rates. Go through all the bills, see what they charged you for. Look in the blue book as to what's generally billed for that. And you can say, well, no, wait a minute, how come you charge me so much more than what's in the blue book? And that can empower you to negotiate something more reasonable as far as getting the bill paid. But the idea here is, and when I tell people to keep in mind, an insurance company isn't going to pay a bill just because they got it from the hospital. Here's a bill, pay it. And I say, oh, no, so wait a minute. Okay, well, if the insurance company wouldn't necessarily pay the bill just because a medical provider sent it to you, why should you? Why should you? Look further into it. Look at the healthcare blue book, and find out what the rates are. Contact Social Security. Find out what the Medicare billing rates are for these services. Get some context. Find out what their billing compares to it, and that'll give you a lot of leverage with the medical provider in the haggling process. So, and I also tell people, ask them, look, they may take different insurances, all right, and different insurance companies and even policies that are offered by those insurance companies can vary on how much they will pay for a particular treatment or procedure. So say to them, look, what insurance company would pay this bill? Okay, name one, and then look into it, find out about it. Would they, is this, if you can get that information, because they just can't pick a number. So negotiate the bill, do it in a timely fashion, empower yourself with this information, and hopefully you'll be able to get them to get the bill down to a reasonable amount. Now, another important thing, once you get an agreed upon amount, all right, tell them to rebill it. Send you a new bill for the amount that you agreed upon. All right. What you don't want to have happen is the provider says, well, we billed you $5,000, but we agree that you pay $3,000. Well, that can have tax consequences, because then the medical provider can say, well, we're knocking $2,000 off the bill. You haggled with us. Okay, we'll take $3,000, but we're knocking the other $2,000 off. Well, that's called debt forgiveness. And the IRS considers that taxable income. So you don't want to end up paying taxes on an amount you didn't think you should have had to pay in the first place for those medical services. So what you need to do is say, all right, we've agreed that we didn't agree to a compromise amount. We didn't haggle it down. We now agreed that this is what I'm going to pay for the medical services I agreed to get way back when. So send me a bill for that amount. That this is the amount that you're now billing as a result of our negotiations, and I then pay that. Because then you have the documentation that you paid the bill in full. No compromise amount, there was no debt forgiveness. You paid it in full as a result of your negotiations. And that you have that paperwork. Should, for some reason, the medical provider issue a 1099 to the IRS for the amount you knocked them down on the bill, you have documentation to show to a revenue agent that this is not debt forgiveness. This is a negotiated bill. I know I've thrown a lot at you, and it's a lot to think about. There's also a podcast that I did on this last month. If you want to listen to that, it covers pretty much the same material. Just sort of listen in the car, whatever you want to do, that might be more convenient for you. I'll provide the link to that podcast. But go over the links. Get the bill, get the information together, contact the providers, and negotiate from a position of strength and knowledge by knowing Medicare billing rates, the healthcare blue book rates, something that shows a context for what is fair and reasonable for the bill, and not necessarily what they charged you, what they billed you for. So that's it for this month. Hopefully we'll have audio on this when it goes through. The next Richardson Law Office's Legal Hangout will be on August 25th at 5 p.m. and we'll talk about a different topic. And I'll tell you what, if you're watching this and it's before August 25th, 2016, shoot me an email to steve@richardsonlawoffices.com and let me know what topic you'd like me to talk about. I'm always looking for suggestions from channel subscribers or people that view the videos on what they'd like to hear about in New Jersey law. I've talked about many different topics, whether it be student loans, applying for them, paying them, collection defense against creditors, bankruptcy, traffic court, drunk driving. There are all sorts of things that we can talk about on the Hangout. So if you had something that's interesting, send me an email to steve@richardsonlawoffices.com and I'll look into putting a program together for that. So that's it. It's kind of hot in here, even then with the air conditioning on, and it's a hot July evening. So I'll leave you to it and enjoy the rest of your summer. I'll see you just before Labor Day on our next Legal Hangout.